Welcome to the High Court Report. Today, we dive into Wolford versus Lopez, a case that asks whether gun owners must ask "Mother, may I" before bringing their firearm into a coffee shop. The court will hear oral arguments on Tuesday, January 20th.
This case perfectly captures the post-Bruen chaos. After the Supreme Court struck down New York's restrictive gun licensing scheme in 2022, establishing that Americans have a right to carry firearms in public for self-defense, states scrambled to find new ways to limit public carry. Hawaii found a creative solution.
Creative indeed. Instead of banning guns directly, Hawaii flipped the script on property law. The state now requires gun carriers to get explicit permission before entering any private business open to the public.
So Jason Wolford and other concealed carry permit holders sued. They argue this effectively eliminates their Second Amendment rights because most business owners never post signs either allowing or prohibiting firearms. You know that awkward moment when you're not sure if you're allowed to bring something into a store, like when you have a dripping umbrella and wonder if you should leave it outside.
Or when you're carrying a big backpack and can't tell if the shop wants you to check it at the counter.
Right. Now imagine that same uncertainty, except instead of soggy floors or theft concerns, you're wondering if you'll commit a felony just by walking through the door. That's the legal minefield Hawaii created for licensed gun carriers.
If you made it this far, share this episode with one person who thinks Supreme Court cases don't affect their daily life, because this decision will determine whether you can legally carry a licensed firearm into most businesses across America. And please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundowns, and follow on YouTube to see shorts. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know.
Let's break down what Hawaii actually did here. The law requires unambiguous written or verbal authorization, or clear and conspicuous signage, before you can carry a gun into any privately owned public space. The devil lives in those details. If a store owner nods when you ask about bringing your gun inside, you still commit a crime. Hawaii demands crystal clear verbal permission or perfect signage.
This creates some strange situations. You can bring bicycles, roller skates, protest banners, muddy shoes, dripping umbrellas, melting ice cream cones, open alcohol containers, boom boxes, and knives into businesses without asking. Only guns require the magic words. That's a bit strange, especially because there's no constitutional right to dripping umbrellas. But Hawaii would argue that firearms pose a significant threat of danger, and dripping umbrellas don't.
Let's talk details. After Bruen invalidated the state's old licensing scheme in June 2022, Hawaii's legislature moved quickly. They enacted this property-based restriction in 2023, essentially preserving the pre-Bruen status quo through different legal mechanisms. Jason Wolford and other permit holders filed suit in federal district court within months of the law taking effect. The district court initially sided with them, granting a temporary restraining order in just 21 days of proceedings. Here's where the procedural history gets interesting. The district court found petitioners likely to succeed on their Second Amendment challenge as applied to private property held open to the public. But the court emphasized these conclusions remained preliminary because of the rushed 21-day timeline. The court specifically noted that Hawaii could potentially change the outcome by providing additional historical evidence during full proceedings. That foreshadowed the eventual reversal.
The Ninth Circuit panel reversed in September 2024. The court acknowledged that carrying onto properties held open to the public likely falls within the plain text of the Second Amendment, but found Hawaii demonstrated sufficient historical tradition supporting consent requirements. In doing so, the Ninth Circuit relied heavily on two historical laws, a 1771 New Jersey statute and an 1865 Louisiana law, calling them historical dead ringers for Hawaii's approach.
When petitioners sought rehearing en banc, the full Ninth Circuit denied the petition in January 2025. But Judge Van Dyke wrote a blistering dissent joined by 5 other judges, arguing Hawaii's law effectively nullifies the Second Amendment rights of Hawaiians.
That's unusually strong judicial language. 6 judges essentially accused Hawaii of constitutional defiance, which caught national attention and strengthened the cert petition.
Wait, defiance just for passing the law? What made Judge Van Dyke so fired up?
No, it goes deeper than that. Hawaii actually defended this law by arguing that the former Kingdom of Hawaii's traditions should override national constitutional principles. In their brief opposing certiorari, Hawaii claimed its restrictions passed constitutional muster because Hawaii has limited the carrying of weapons in public spaces since at least 1852.
Hold on. They're saying 19th century Hawaiian kingdom laws trump the U.S. Constitution and our national founding traditions?
Exactly. Judge Van Dyke saw this as Hawaii essentially rejecting the Supremacy Clause. The state argued that local Hawaiian traditions from before statehood should supersede both founding-era principles and the national historical tradition that Bruen requires courts to examine.
Right. And Van Dyke connected this to a broader pattern. After Bruen recognized robust public carry rights, Hawaii immediately scrambled to preserve its pre-Bruen restrictions through property law workarounds. The judge saw this as an end run around a Supreme Court decision Hawaii simply disagreed with.
So the defiance accusation wasn't just about passing any gun law, it was about Hawaii's specific argument that local historical traditions can override national constitutional requirements.
Wolford, the gun owner, appealed the Ninth Circuit knockout to the Supreme Court, which granted certiorari limited to the specific question whether the Ninth Circuit erred in holding, in direct conflict with the Second Circuit, that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier.
That's a mouthful, but it breaks down into something simpler. Can Hawaii flip the script to require gun carriers to secure explicit permission before bringing a gun onto another person's property?
Exactly. And the circuit split makes this cert-worthy. The Ninth Circuit said, yes, Hawaii can do this. But the Second and Third Circuits reached the opposite conclusion in similar cases.
Okay, let's move on to the arguments. The gun owners make 3 main arguments. First, they say carrying guns on private property open to the public clearly falls within the Second Amendment's protection. The Supreme Court already ruled that nothing in the amendment draws a home versus public distinction.
Second, they argue Hawaii effectively abolished public carry rights. When most property owners stay silent about gun policy, licensed carriers face a minefield where they cannot know if entry violates the law.
Third, they attack Hawaii's historical evidence. The state points to Colonial and Reconstruction-era laws, but petitioners say these scattered examples from random time periods cannot establish a well-established tradition.
Hawaii fires back with 3 counter-arguments. The state claims the Second Amendment never protected armed entry onto private property without owner consent. They trace this principle back to English common law, where every entry onto private property without the owner's leave constituted trespass.
Hawaii also argues the law vindicates fundamental property rights rather than restricting gun rights. Property owners who open their premises to the public do not forfeit their right to exclude firearms.
The state then points to multiple historical analogs. They cite 6 Colonial and Reconstruction-era laws requiring consent before carrying guns on private property, calling them historical dead ringers for Hawaii's approach.
The United States filed an amicus brief supporting the petitioners, making 3 sharp arguments against Hawaii's law. They'll participate in the oral arguments.
The United States argues Hawaii's law serves an improper purpose, suppressing gun rights rather than protecting property rights. Normal property law already lets owners post "no guns" signs. Hawaii's law makes gun carrying harder by singling out firearms for discriminatory treatment.
The feds also say Hawaii created an unconstitutional, near-complete ban on public carry. Most owners never post signs either way, so the law effectively means licensed citizens cannot carry guns in public at all.
Finally, the United States attacks Hawaii's historical evidence. Traditional property law distinguished between private property closed to the public versus property open to the public. Anyone could enter open property unless owners restricted access. Hawaii inverted this traditional rule.
One of Hawaii's key historical precedents comes from 1865 Louisiana, a former Confederate state before readmission to the Union. Critics note the irony of using Reconstruction-era legislation from a racist regime to justify modern constitutional restrictions.
Hawaii's strongest historical analog involves a 1771 New Jersey anti-poaching law designed to stop people from hunting on private estates. Courts now debate whether colonial hunting regulations justify restricting modern Americans from carrying guns into Walmart. In opposing Wolford, Hawaii made a remarkable argument. The state claimed its law passes constitutional muster because Hawaii limited the carrying of weapons in public spaces since at least 1852. Hawaii essentially argued that the former kingdom's traditions trump both founding-era principles and national constitutional tradition. This raises fundamental questions about constitutional implementation. Can states achieve through indirect property law mechanisms what they cannot accomplish through direct gun bans? The Supreme Court previously ruled that what cannot be done directly cannot be done indirectly.
The case also exposes the practical challenges of constitutional rights in modern society. Much of contemporary public life occurs in spaces that private entities own but open to the public: shopping malls, restaurants, stores, coffee shops.
Property owners who want to allow guns must post clear and conspicuous signage, but the law never defines what qualifies. Too small a sign? Your customers face criminal liability. Wrong font? Oops. Your patrons become felons. Hawaii's approach creates a legal minefield, but I can appreciate legislatures crafting creative solutions.
The enforcement mechanism relies on criminal sanctions, which distinguishes this from simple civil trespass law. Hawaii backs its consent requirement with criminal penalties, raising questions about when enforcement crosses from protecting property rights into suppressing constitutional rights.
This case fits into a broader pattern of blue state resistance to Bruen. States like New York, California, and Hawaii scrambled to find creative workarounds after the Supreme Court recognized robust public carry rights.
The historical analysis reveals deeper tensions. Bruen requires courts to find analogs in the nation's historical tradition of firearm regulation, but determining which scattered colonial or Reconstruction-era laws constitute sufficient precedent remains contentious.
The property rights angle complicates the analysis. Unlike pure gun control measures, Hawaii's law arguably vindicates legitimate property interests. Property owners genuinely possess fundamental rights to exclude others from their premises.
Yet, the United States argues Hawaii's exemptions reveal the law's true purpose. The state exempts law enforcement officers and government employees going to and from work, suggesting the statute seeks to restrict public carry to favored groups rather than protect property rights. The case also touches on burden-shifting principles. Hawaii requires gun carriers to obtain explicit authorization through specific procedural requirements. This may effectively nullify constitutional rights through administrative burden rather than direct prohibition.
Looking ahead to oral arguments, this case sets up some absolutely wild hypotheticals that the justices love to explore. The interesting legal realities Hawaii created will generate incredible questioning from the bench.
Oh, the hypotheticals will be bonkers. Picture Justice Gorsuch asking, "Counsel, if Hawaii can require explicit permission for firearms, could a state pass a law saying no one can speak on another's property unless they first receive written authorization from the property owner?"
Right, because if Hawaii's theory works, states could essentially eliminate any constitutional right by forcing people to play Mother May 1 with property owners. Free speech, free exercise of religion, due process, all could require advance permission slips.
Justice Kavanaugh might ask, what if a state required explicit consent before anyone could practice their religion on private property open to the public? Would that survive First Amendment scrutiny just because it operates through property law?
And Justice Thomas will probe the historical analogies with surgical precision. He'll ask Hawaii's attorney to explain exactly how a 1771 anti-poaching statute justifies regulating modern Americans walking into Starbucks with concealed carry permits.
The most fascinating hypothetical might involve Justice Barrett asking about enforcement. Counsel, if a business owner gives unclear permission, maybe they shrug or say, I guess, does the gun carrier commit a felony? How does law enforcement determine whether consent was sufficiently unambiguous?
You're right. I'd love to see the hypotheticals that Hawaii's lawyer, Neil Kachel, will receive as he prepares for oral argument.
Looking ahead, this case could reshape how Second Amendment rights operate in modern society. If Hawaii prevails, other states might adopt similar property-based restrictions, potentially creating a patchwork of incompatible rules across jurisdictions.
Conversely, if petitioners win, the decision might establish stronger protection for public carry rights and limit states' ability to circumvent constitutional protections through creative legal theories.
Whatever the outcome, Wolford versus Lopez will significantly impact how Americans exercise Second Amendment rights in the countless privately owned but publicly accessible spaces that define modern life. That wraps our analysis of this fascinating case. Join us next time as we continue tracking the Supreme Court's most important decisions. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown and follow on YouTube to see shorts. Talk to you soon.